Barbara is 71 years of age. She resides in Ohio. Her offspring, James, is 43 and faced a layoff 8 months back. He possesses 2 children attending school and a house payment he is finding difficult to maintain. Barbara has accumulated savings. She owns a property appraised at $400,000 that she purchased for $80,000 3 decades ago. She possesses an investment portfolio featuring equities she has retained for generations. She wishes to support her child. It is her wealth. She worked for it. She ought to be permitted to transfer it to her relatives. So, she performs the action most parents would undertake. She drafts James a payment for $20,000. Then, she moves some appreciated securities into his title. Then, because she has been informed that one can gift up to $19,000 annually without encountering tax issues, she provides another $19,000 the following year. 3 years later, Barbara suffers a fall. She is in the hospital.
She requires extended term care. Her reserves have depleted faster than anticipated. She requests government medical assistance to help cover nursing facility charges. The authorities examine 5 years of every financial action she executed, every single payment, every move, every donation. They discover the $40,000 in currency and the equity transfer. They compute a disqualification window. Barbara is barred from government assistance benefits for months, possibly longer. She resides in a nursing facility. She cannot cover costs privately. The wealth she transferred to James is exhausted. James cannot restore it. The tax authority assured her everything was perfectly fine. The annual gift provision declared $19,000 per recipient was permitted. She filed 0 gift tax paperwork because she owed 0 gift tax. Government medical assistance operates under a completely separate set of regulations that have 0 relation to the tax authority, and nobody informed Barbara. This presentation is for informational objectives only and does not constitute tax or financial advice. Confer with a qualified tax specialist and a licensed elder law attorney prior to executing any decisions regarding your personal situation. My name is Kevin Retires. Every week I analyze the tax guidelines, the financial hazards, and the tactics that safeguard retirees from the matters nobody else is explaining. If that sounds like something you require, click the subscribe button right now and enable notifications so you never overlook a video. Today, I am going to guide you through the 3 specific regulations the tax authority and the government apply that penalize retirees for assisting their offspring. I am going to clarify why the $19,000 gift exclusion is one of the most misunderstood guidelines in retirement. I am going to demonstrate the capital gains hazard that destroys wealth when parents provide the improper asset to their children. And I am going to provide you with a clear action strategy for how to aid your relatives without initiating any of these outcomes. Most of what I am about to clarify is not widely known. Your accountant may understand the gift tax regulations. Your financial advisor may understand capital gains, but very few individuals clarify how these regulations interact with one another and with government medical assistance in a manner that costs actual families actual money. Let me commence with the regulation that catches the most people by surprise. The tax authority annual gift tax exclusion in 2026 is $19,000 per recipient. That signifies you can provide up to $19,000 to any individual in a single calendar year without submitting a gift tax return. A married couple can provide $38,000 per recipient per year. You can provide this to as many individuals as you desire. You can provide $19,000 to each of your 3 children, 7 grandchildren, and 2 neighbors, and owe 0 to the tax authority and submit 0. If you surpass $19,000 to a single recipient in 1 year, you submit Form 709 with your tax return, but you almost certainly owe 0 gift tax. The lifetime gift and estate tax exclusion in 2026 is $15 million per individual. That figure was established permanently under the One Big Beautiful Bill Act. You would have to donate $15 million over your entire lifetime before a single dollar of gift tax is actually owed. So the tax authority regulation is clear and relatively generous. Donate under $19,000 per person per year, and you do not even have to report it. donate more. Reported on Form 709. Diminish your lifetime exclusion. Never remit $1 of actual tax unless your cumulative lifetime donations surpass $15 million. Here is where the hazard commences. Government medical assistance is not the tax authority. Government medical assistance is a combined federal and state program. It possesses its own regulations, and its regulations for donations are totally different. When you petition for government medical assistance extended term care benefits, the program that covers nursing facility care, home health assistance services, and comparable extended care, the state examines your financial background for the 60 months immediately before your petition date, 5 years. Every donation, every transfer, every asset sold below fair market value during that 5-year window is reviewed. And this is the critical distinction that destroys families. The tax authority gift tax exclusion provides zero protection under government medical assistance regulations. None. A donation of $500 performed last year can initiate a government medical assistance penalty window just as surely as a donation of $50,000. The government medical assistance system does not care whether you submitted a gift tax return. It does not care whether you owed any gift tax. It examines only whether money or assets exited your control during the look-back window. The penalty for donations within the government medical assistance look-back window is computed by dividing the total amount donated by the average daily price of nursing facility care in your region. This daily price is called the penalty divisor, and it varies by region. In a region where the average daily nursing facility price is $350, a donation of $35,000 creates a 100-day penalty window. In a region with a higher price, the identical donation creates a shorter penalty. In a lower price region, a longer penalty. But in every region, the math functions the same way. The donation amount divided by the daily rate equals the number of days you are ineligible for government medical assistance benefits. The penalty for donations within the government medical assistance look-back window is actual, computed precisely, and cannot be appealed simply because you were unaware of it. The resulting figure is the number of days you must wait before government medical assistance will settle your bills. During that penalty window, you are expected to settle for care privately. If you have already depleted your assets attempting to qualify for government medical assistance and you have zero money remaining, and the penalty window is still active, you are in a deeply serious situation, and the penalty window does not commence until the day you are otherwise eligible for government medical assistance. The timer does not start on the day you provided the donation. It starts the day you petition after depleting your assets. So the worst case is that you have provided money, depleted everything else, petitioned for government medical assistance, and only then does the penalty window commence. This is not a theoretical risk. Extended term care is the largest unplanned expense in retirement, and it is one that most retirees do not prepare for until it is already happening. According to the Department of Health and Human Services, approximately 70% of individuals reaching 65 today will require some form of extended term care during their lifetime. More than 40% will pass time in a nursing facility. The median annual price of a private room in a nursing facility in the United States surpassed $100,000. Medicare compensates for skilled nursing care after a hospital stay for up to 100 days under very specific conditions. After day 100, Medicare ceases for most retirees who require extended care beyond what Medicare covers. Government medical assistance is the only program accessible, and government medical assistance is the program that reviews every donation you provided in the last 5 years. This is not a theoretical risk. Extended term care is the largest unplanned expense in retirement. The median annual price of a private room in a nursing facility in the United States is beyond $100,000 per year. Medicare compensates for skilled nursing care for up to 100 days under specific conditions. After that, it ceases. For most retirees who require extended care, government medical assistance is the only program that covers it, and government medical assistance is the program that reviews every donation you provided in the last 5 years. Let me guide you through 3 individuals so you can witness exactly how this plays out. Dorothy is 68. She provides her daughter $5,000 every December. She has performed this for 4 years. She never submits a gift tax return because the amounts are beneath the annual exclusion. She presumes everything is perfectly fine with the tax authority, so it must be perfectly fine with government medical assistance. At 72, Dorothy suffers a stroke. She requires nursing facility care. She petitions for government medical assistance. The state reviews 5 years of banking records. They discover $20,000 in holiday donations distributed over 4 years. All of it is within the government medical assistance look-back window. The state computes a penalty window based on the total transferred. Dorothy is denied government medical assistance coverage for a window of months because of donations she provided to her own daughter from her own money within the annual tax authority limit. Nobody informed Dorothy the tax authority limit and the government medical assistance limit are two separate systems with zero connection to each other. Robert is 70. He owns a property valued at $350,000. He purchased it in 1990 for $60,000. His child Michael is experiencing a divorce and requires housing. Robert decides to deed the property to Michael to assist him. He is not distributing it. He is donating it to his child. 2 years later, Robert experiences a health emergency. He petitions for government medical assistance. The property transfer within the 5-year look-back is flagged. The state values the transfer at $350,000, the fair market value at the hour of transfer. The penalty window computed from that amount is severe. Robert is ineligible for government medical assistance for an extended window. He owns zero property. He possesses limited savings. He is waiting for a penalty window to conclude while incurring nursing facility prices he cannot settle. Robert also handed his child a tax issue he did not intend to create. Michael currently owns a property with a cost basis of $60,000, the price Robert paid in 1990. When Michael eventually distributes that property, he will owe capital gains tax on the difference between $60,000 and whatever the property distributes for. If it distributes for $350,000, Michael owes tax on $290,000 in capital gains. If Robert had simply retained the property and left it to Michael through his estate, Michael would have received a stepped-up basis equal to the fair market value at the date of Robert's passing. Michael could have distributed the property the next day and owed zero in capital gains. Robert provided his child a $350,000 property and a significant capital gains tax bill. He intended to provide him a donation. He created a liability. Linda is 73. She possesses an investment portfolio containing equities she acquired years ago for $20,000. The equity is currently valued at $90,000. Her child is launching a small business and requires capital. Linda transfers the equity to her child to assist. Linda's donation is within the annual exclusion for the year. Zero gift tax, zero Form 709 required. But Linda's child currently owns equity with a cost basis of $20,000. When the child distributes it to fund the business, she owes capital gains tax on $70,000 of appreciation. At the 15% long-term capital gains rate, that is $10,500 in federal tax on what was supposed to be a tax-free donation from a parent. If Linda had simply distributed the equity herself and provided her child the currency, Linda might owe tax on the identical gain. But Linda's earnings and bracket matter here. If Linda is in a lower earnings bracket and her long-term capital gains rate is 0%, which applies to sole filers with taxable earnings up to $47,025 in 2026, she could have distributed the equity herself, paid zero capital gains tax, and provided her child $90,000 in currency with zero embedded tax liability. Identical asset, identical intention, totally different tax outcome depending on who distributes. The long-term capital gains rates in 2026 are 0%, 15%, and 20% depending on earnings. For a sole filer, the 0% rate applies to taxable earnings up to $47,025. For a married couple submitting jointly, it applies to earnings up to $94,050. Many retirees in their early retirement periods before retirement benefits and required minimum distributions commence are in this 0% bracket. They possess a window where they can distribute appreciated assets themselves, remit zero federal capital gains tax, and then provide the proceeds to relatives as currency. This is one of the most powerful and underutilized tactics in retirement. It eliminates the embedded gain. It eliminates the carryover basis complication for the receiver. And if performed in years before the government medical assistance look-back window is a concern, it can be structured to minimize that risk as well. The window is narrow. It requires understanding your earnings in the year of the distribution. But for retirees who possess it accessible, it can be worth tens of thousands of dollars compared to simply transferring the appreciated asset directly. If this video is displaying you hazards your relatives has never debated, click the like button right now and distribute this with anyone you know who is contemplating providing money or property to their offspring. They require to witness this before they perform. Subscribe and enable the bell so you never overlook a video like this one. If what you just heard about government medical assistance and the look-back window is something your relatives has never debated, click the like button right now. This is precisely the kind of information that needs to reach people before they perform a decision they cannot reverse. Subscribe, and enable the bell. I publish every week, and the following video covers another version of this hazard. Now, let me clarify the stepped-up basis regulation in full, because it is one of the most valuable protections accessible to retirees, and it vanishes completely the moment you donate an appreciated asset away during your lifetime. When you pass and bequeath an appreciated asset to your heirs through your estate, the cost basis of that asset resets to its fair market value on the date of your passing. This is designated the step-up in basis. Under IRC Section 1014, confirmed and intact in 2026 under the One Big Beautiful Bill Act, your heirs inherit the asset at its current value, not what you remitted for it decades ago. The practical effect is enormous. If you acquired equity for $20,000 40 years ago and it is valued at $300,000 today, and you bequeath it to your child at passing, your child's cost basis in that equity is $300,000. If your child distributes it for $300,000 the week after you pass, they owe zero capital gains tax. The $280,000 in appreciation that accumulated during your lifetime simply vanishes for tax purposes at the moment of inheritance. Now consider what transpires if instead of bequeathing that equity to your child at passing, you provide it to them as a donation today. Your child receives the equity with your original cost basis of $20,000. If they distribute it for $300,000, they owe capital gains tax on $280,000. At a 15% federal rate on long-term gains, that is $42,000 in federal capital gains tax. At 20% for higher earners, it is $56,000 plus state taxes in most regions. You provided your child a donation valued at $300,000. You also provided them a tax bill valued at tens of thousands of dollars. They may not even realize it until they attempt to distribute. The regulation is straightforward, and it matters enormously for planning. Never donate a highly appreciated asset during your lifetime if you can bequeath it through your estate instead. The step-up in basis at passing eliminates the built-in gain totally. Zero tax, nothing. The donation during your lifetime preserves that entire gain and transfers it to your child as a future tax liability. There are situations where donating makes sense. If the asset has not appreciated significantly, the basis complication is minimal. If you are performing annual donations of currency, there is zero basis concern at all. If your estate is significant enough that estate tax is a consideration at the $15 million threshold, donating can diminish the taxable estate. But for most retirees with appreciated equity, appreciated property, or long-held investments, the step-up in basis at passing is worth more than any lifetime donation strategy. Here is your action checklist. 5 specific steps based on where you stand right now. One more hazard deserves its own moment because it affects retirees who are attempting to aid their offspring utilizing their IRA accounts. When a retiree obtains a distribution from a traditional IRA and then provides the currency to a child, 2 things transpire. First, the total distribution is ordinary earnings to the retiree in the year it is withdrawn. If you pull $60,000 out of your IRA and provide it to your child, you owe earnings tax on $60,000 at your rate. The child owes zero on receiving the currency donation, but you remitted the tax to fund it. Second, that $60,000 withdrawal may push your modified adjusted gross earnings over the IRMA threshold for Medicare, triggering higher premiums 2 years later. It may render more of your retirement benefits taxable, and it is still a transfer that government medical assistance will review if it occurred within the 5-year look-back window. Retirees who fund large donations to offspring by obtaining IRA distributions are remitting earnings tax on the transfer, potentially triggering Medicare surcharges and still creating a government medical assistance look-back complication. They presume they are behaving responsibly by utilizing their own money. They do not realize that the funding source adds a tax layer on top of the donation consequences. The superior approach in many situations is to provide currency from a taxable investment portfolio or savings, where the withdrawal itself does not create a new tax event, rather than funding donations from distributions that are totally taxable as ordinary earnings. Step 1. If you are currently performing annual donations to offspring or grandchildren, verify that those donations are not creating a government medical assistance look-back complication. If you possess any possibility of requiring extended term care within the upcoming 5 years and at 65 or older, most people do. Confer with an elder law attorney prior to performing any more donations. The 5-year government medical assistance look-back window is running whether you are aware of it or not. Step 2, never provide an appreciated asset to a child or grandchild during your lifetime if you can bequeath it through your estate instead. This includes equity held in investment portfolios, real estate, business interests, and collectibles. Compute the embedded gain prior to you decide to donate. Subtract your original cost from the current fair market value. That difference is the tax your receiver will eventually owe if you provide it now instead of bequeathing it at passing. In most situations, the step-up in basis renders waiting far more valuable than providing. Step 3. If you desire to aid a child with a large expense, such as education or medical care, the tax authority provides 2 unlimited exclusions that government medical assistance does not penalize in the same way. Direct tuition payments performed directly to a qualifying educational institution are excluded from gift tax totally with $0 limit. Direct medical payments performed directly to a healthcare provider for someone's medical expenses are excluded from gift tax with $0 limit. These payments bypass the annual exclusion totally and are not transfers of assets in the same way that currency donations are. Confer with an elder law attorney about how your region treats these payments under government medical assistance regulations prior to presuming they are totally protected. Step 4. If your estate is beneath the $15 million federal estate tax exclusion in 2026, and for most retirees it is, the urgency to diminish your estate through lifetime donating is low. The step-up in basis benefit of retaining appreciated assets until passing is likely worth more than any estate tax savings from providing those assets away. Now, this computation changes significantly if your region possesses a regional level estate tax with a lower threshold. Several regions possess estate tax exclusions well beneath $15 million. Understand your region's regulations prior to presuming you possess zero estate tax exposure. Step 5, if you have already performed donations within the past 5 years and you are nearing an age where extended term care might become necessary, confer with an elder law attorney immediately. A government medical assistance asset protection trust or other planning tools may aid mitigate exposure. But these strategies require time to implement and typically require assets to be in a qualifying structure for 5 years before they are protected. The sooner you perform, the more options you possess. Here is the antagonist in this narrative. It is not the tax authority. The tax authority gift tax regulations are relatively generous. The annual $19,000 exclusion is real. The $15 million lifetime exclusion is real. The step-up in basis at passing is one of the most valuable provisions in the entire tax code for middle-class families with appreciated assets. Prior to I get to the antagonist, let me address the inquiry I know is approaching in the comments. Can you obtain the donations back? In most situations, no. A donation is a completed transfer. Once you provide money or property to another individual, you possess zero legal right to demand it back. If your child utilized the money to pay down debt, invested it, or distributed it, there is nothing to return. In the government medical assistance context, the state may request that the receiver return the donated amount to cure the transfer. If the money still exists and the child is willing and able to return it, the penalty may be diminished or eliminated. But if the money is gone, or the child refuses, or the property has been distributed, the options are very limited. This is why timing matters so much. The 5-year government medical assistance look-back window signifies that donations provided more than 5 years before a government medical assistance petition are generally not counted. If you are healthy and you are planning to provide donations to relatives, performing it earlier rather than later keeps those transfers outside the look-back window by the time you might require care. But this requires planning at 60 or 65, not at 73 when a health event has already transpired. A government medical assistance asset protection trust, sometimes designated a MAPT, is a legal tool that some families utilize to move assets outside of government medical assistance's reach. Assets placed in a properly structured irrevocable trust are generally not counted for government medical assistance eligibility objectives, but only if the trust was created and funded more than 5 years before the government medical assistance petition. The 5-year timer on the trust runs from the date of funding, just like the look back on direct donations. This is not a strategy you can implement after a health crisis. It is a strategy that requires setting it up years in advance. The antagonist is the assumption that the tax authority regulations are the only regulations that apply to providing money and property to relatives. They are not. Government medical assistance operates under a totally separate framework. Capital gains tax operates under a totally separate framework. State-to-state taxes operate under a totally separate framework. And almost none of these regulations are explained together in a single conversation prior to a retiree performs a decision they cannot reverse. Barbara provided her child $40,000 and some appreciated equity because she wished to aid him. She violated zero tax authority regulation. She owed zero gift tax. She submitted nothing incorrect. She is in a nursing facility with a government medical assistance penalty window running because she was unaware of a 60-month look-back regulation in a program she had never pondered about. Dorothy provided her daughter $5,000 at December for 4 years. The tax authority would deem it insignificant. Government medical assistance deemed it a transfer within the look-back window. Robert provided his child a property he intended to provide him security. He provided him a carryover basis that turned into a capital gains tax bill and triggered a government medical assistance penalty that left Robert with zero. These are not wealthy families performing sophisticated errors. These are ordinary retirees performing ordinary things with money they earned and saved and intended to share with people they cherish. The regulations that penalize them are real, enforced, and almost never explained in advance. This is Kevin Retires. If this video displayed you something your relatives requires to comprehend prior to anyone provides away any money or property, distribute it right now. The decision to provide is irreversible in most situations. The knowledge needs to come first. Inform me in the comments, has your relatives ever performed a donation and later discovered it possessed a consequence nobody anticipated? I read every single one, and the most common situations become future videos.